we don't need to know anything about the Constitution in order to get textualism, right? So textualism, Scalia thinks, applies to any judge, no matter sort of what court they're in, what they're ruling about. They should look at the text and construe it reasonably, and they'll get their answer as to what is right or wrong, how they should rule. But when we look at constitutional interpretation, there's an added layer of complexity. So we're going to talk about Scalia's theory about constitutional interpretation. How is interpreting a constitution different from interpreting, the state code or your local legal code? Scalia says the great divide with regard to constitutional interpretation is not the divide between the framer's intent and the objective meaning, but rather between what he says the original meaning and the current meaning. So he thinks his view's often mistaken for this view that we should do what the framers intended, or should we give it the objective meaning? He says that's not really what I think. He says I am rather arguing that we should read the Constitution in accordance with its original meaning rather than its current meaning to us. So we'll have to figure out what that means. This is going to be called the debate between originalism and living constitutionalism. So one practical example of this debate between originalists and living constitutionalists is on the question of whether capital punishment counts as cruel and unusual under the Eighth Amendment. So the Eighth Amendment says, that we're going to prohibit cruel and unusual punishment. If punishment's cruel and unusual, you can't do it. Originalists are going to say, in this case, that what's cruel and unusual depends on what counted as such to its writers, that is, the framers and the original audience. So what did those people think was cruel and unusual? That's what's outlawed by the Eighth Amendment. Living constitutionalists, however, are going to say that what's cruel and unusual depends on what counts as cruel and unusual to us. So what do we think is cruel and unusual? So Scalia is going to allow a punishment that's, even if we think it's cruel and unusual, as long as the framers did not think that it was cruel and unusual, whereas living constitutionalists are going to say no. If we think it's cruel and unusual, then it's not allowed by the Eighth Amendment. So the guillotine, for example. I'm not sure exactly if, I guess I should look this up, right? I should think about this, but I don't know if the guillotine has ever been used for executions in the United States. I assume that it probably has. But that's the sort of thing that we would say, no, that seems like it's sort of beyond the pale, we're not going to allow that. Now, on Scalia's view, and maybe this is controversial, or maybe this is a strike against his view, right? If the framers thought that the guillotine was not cruel and unusual, they thought it was fine, then in principle that would be fine today. So what are some other cases where originalists and living constitutionalists are going to disagree? We're just sort of looking for other places in the law where there's this part of the statute that sort of looks like it's giving us some sort of principle, and then we're not quite sure how to interpret it or what to do with it. So I think we don't have to look very far in order to find examples of this. So in the First Amendment, for example, we get this free speech clause that says the freedom of speech will not be abridged. What does that mean exactly? Does that mean that I get to say whatever I want, whenever I want to? Presumably the framers didn't have Facebook or Twitter in mind when they wrote the First Amendment. And so maybe it's a bit unclear what exactly they mean when they, whether or not what they would have said or what they would have thought about the freedom to speak on Facebook or Twitter. But there's this sense that we have about what counts as free speech and whether or not, speech on Facebook and Twitter is the kind of thing that's protected or not. And so that's one case where we might, maybe whether we're originalists or living constitutionalists is going to have an effect on how we'd rule. There's some other cases that sort of raise these similar issues. So we'll look at the Equal Protection Clause later in the semester. What does it mean to get equal protection under the law? We'll look at affirmative action, for example. Does affirmative action policies where we're potentially giving preferential treatment to historically disadvantaged groups, like women or racial minorities, is that giving equal protection to people under the law? Yes or no, and why or why not? So the originalists maybe had like one view. The framers didn't pass the 14th Amendment, but when the 14th Amendment was passed, there's one thing that sort of phrase was taken to mean, and then there's a different maybe meaning today, and so that would be another place where that debate comes up. Now, as I think I mentioned before, Scalia is an originalist, right? So he thinks that there are two problems with living constitutionalism. We should accept the originalist position, and we'll identify those problems. So the first one, if living constitutionalism is true, then we could end up with fewer liberties than we started out with. So what are some examples? He gives a list of things that states can't do anymore that they could have done in the past. So here's one. States can't use evidence obtained by an unlawful search. So when the state finds some information, but they got the information unlawfully, they can't use that evidence. Now, maybe it's good that they shouldn't, but he's saying, let's just be clear, that's a liberty that states would have had in the past that we don't have now. And we've gotten there because we think this living constitutionalism view is true, that like what counts as a lawful search has sort of changed in our minds. Presumably the framers, right, would have thought that freedom of speech protected people who wanted to invoke God at public school graduations, but maybe the way that we've interpreted the law since then has allowed us to restrict those liberties, and so he thinks, again, that's another problem with living constitutionalism. It's ruling out our ability to do certain things. So I'll just run through some of the others. These days, as opposed to at the framing, the founding of the Constitution, states can't elect representatives to state legislatures in the same way that the federal government elects senators to Congress. States can't terminate welfare payments as soon as evidence of fraud is received. States can't require voters to own property. States can't prohibit anonymous campaign literature. States can't prohibit pornography. So all these examples, right, are things that states or individuals can't do now that they could have done given the framers' understanding of the Constitution. And Scalia, again, maybe some of these things are good, but he's saying there's just ways in which we're less free than we were before. An example that he sort of emphasizes and spends some time on is this idea, the Confrontation Clause of, I believe, the Sixth Amendment. So the Confrontation Clause said that people who are accused have a right to be faced by the accuser. And he's talked about how maybe there are children who are involved in some sort of crime, see a criminal commit some crime, or abuse cases, right, where they've decided that it would be too traumatizing for the individual to have to face their accuser, so they sort of record the testimony and they like play that in court rather than actually having them up there sitting in front of the person who's accused, sort of saying, this is what happened. Now, there are all sorts of reasons why we might think that's a good thing, right? We might think it's intimidating for a kid to say in front of someone who's abusing them that person was abusing me. And so it might be hard to get a kid to be honest in that case. But Scalia, again, he says, maybe it's a good thing, but let's not forget that we're losing a liberty that people had, that liberty to be faced by the person accusing you, and maybe that's something worth protecting. So that's the first kind of problem. We're going to end up with fewer liberties. Here's the second kind of problem. If living constitutionalism is true, then people will want Supreme Court justices who interpret the Constitution the way they think it ought to be interpreted. So the problem with this is that Supreme Court appointments are going to be politicized. If the judges just rule in accordance with sort of how they think we could read the Constitution, then people are going to want those justices who agree with them. They're going to vote for political candidates who are going to nominate those kinds of justices. And the next thing you know, selecting the president, who they're going to nominate for the Supreme Court is going to be like an important consideration when we're deciding on the president, something like that. And sure enough, I think that's exactly what we see. Now, why is that bad? The reason it's bad for Scalia is that it's going to result in majority rule. Right? Whatever most people think is the right way to interpret the Constitution, they're going to get their people in power, and they're going to get their Supreme Court justices. And so the Supreme Court then is ultimately just decided by voting. It's not we're not passing laws in the way that we ordinarily would and decide what our rules are through the legislative process. So he thinks this is going to lead to the oppression of minorities, not the protection of them. Now, I think that Scalia sort of gets this roughly right is evidenced by what we saw with the last election. So right before, in fact, maybe it's, I'm trying to think, was it Scalia who died right before the election? No, that doesn't seem right to me. It must have been, though. Yeah. So maybe like in a cruel twist of fate, right? So Scalia passes away, and Obama nominates Merrick Garland for the Supreme Court, but the Republicans say, no, we're not really going to vote on this candidate because the election's coming up. We're going to wait until there's a newly elected president, and we're going to let that person sort of pick who they want to nominate. We'll vote on that person's nomination. Well, it turns out, right, Merrick Garland never was approved by the Senate, and we get Trump winning the presidency and nominating Neil Gorsuch, and then Neil Gorsuch gets confirmed by the Republican Senate. And so I think what we see there in that moment is exactly the thing that Scalia was worried about with kind of living constitutionalism. We're getting the politicization of Supreme Court appointments. Many people maybe will say precisely the reason they voted for Trump was so that he would nominate sort of conservative Supreme Court justices, and in a way, right, that's what Scalia is sort of warning against here. Now, one example he uses here was the I believe the 19th Amendment. The amendment that gives women the right to vote, and he says, who thinks that today, if women didn't have the right to vote, we would pass an amendment? He thinks, no, we wouldn't pass an amendment. We would just have the Supreme Court sort of say, oh, well, this equal protection of the laws in the 18th and 14th Amendment gives women the right to vote, and so they have it. So he thinks, rather than going through that legislative process, right, which they've done in the past, this politicization, the living constitutionalism stuff, has led us just to rule through the judiciary. All right, so we're at the end of this piece by Scalia. Next time we'll look at a piece by Dworkin. In the meantime, right, we want to think about, do we find Scalia's arguments for originalism and against living constitutionalism persuasive? Or do we think, oh, those arguments aren't that persuasive? We should be convinced by maybe living constitutionalism is true. Whatever that your view is at now, you can sort of put a pin in it, right? We're going to look at Dworkin next time, and he's going to maybe give us some reasons to be skeptical of originalism and be more attracted to his version of what Scalia calls living constitutionalism. So see you next time.